I am appearing for the respondent in the first case, my lord, in the appeal filed by the state. My lord, it was to be decided finally, my lord, a very short question. And my lord, the issue is, my lord, that in 2018, my lord, an eligibility test, my lord, that is the teacher's eligibility test was conducted by the state. And the appointments were to be in phases. The only question is that after 2018, in 2022 September, the government issued advertisement to fill up the posts. At that stage, my lord, two issues arose. One, my lord, they deprived certain people of age relaxation and they deprived the EWS category from the benefit of marks, my lord. The first thing, age deprivation, and this was only on one ground, common ground by the state. State said that in September 2022, it was a fresh recruitment process. Therefore, they are not entitled for age relaxation and EWS benefit also, my lord. Regarding the first part, my lords, in the last month has delivered a judgment, my lord. Lordship have categorically held same recruitment process, same advertisement of 2018, and the same trigger point of 2022, my lord, when they deprived of EWS and deprived of age relaxation only on one ground, that it is a fresh recruitment process, we will not give you the benefit. Lordship has categorically held, my lord, in the age relaxation matter that we have filed along with our IA, my lord. Lordship has categorically held that it was a second stage of 2018 because of COVID and other reasons, my lord. Lordship has given a very detailed judgment, my lord. So Lordship has held, my lord, that in 2022 September, it was second phase of the 2018 recruitment process. My lord, first aspect having been decided by a Lordship about age relaxation, my respectful submission is, the state appeal before your Lordship would see, my lord, 10, 12 grounds. Each of the ground is the same, that is a fresh recruitment process. Each ground, my lord, I have gone through. So this appeal is only on one ground, which concluded by my lord's judgment, my lord, delivered on the last month. If that is final, they have to follow that.
In fact, your lordship, it is not exactly similar in respect of application of the EWS reservation is concerned. In fact, on the last date, your lordship, on interim orders, while your lordship was hearing us on interim orders, there was an observation that now the selection pertaining to the year 2023 has been carried out. And appointments in pursuance to that selection have been were permitted to be issued by the Honorable Court. Now, these persons are these candidates are candidates belonging to the 2008 who had participated in the 2019 recruitment, and are claiming that now the vacancies now arising, they should be given appointment under the EWS quota. So that cannot be done. Now, once the process has much water has flown, two recruitment advertisements have already been issued subsequent to the process in which they participated. In fact, even in the second recruitment advertisement, they probably participated and uploaded their documents in respect of EWS. They were not eligible. At the time when the recruitment advertisement was issued, the minimum qualifying criteria for EWS was 60%. None of them qualified. And since none of them qualified, they could not have been made eligible for appointment to that post. Now, in the second recruitment, when the EWS, there was an amendment and the qualifying marks of the EWS category was reduced to 50%, only then they say that they become eligible. Now, at this time, your lordship, there is a DOPT circular, an office memorandum on which we are relying, which says that the EWS vacancies cannot be carried forward to the next recruitment year. Now, since the EWS vacancies could not be carried forward, a fresh calculation of EWS vacancies in the fresh recruitment was undertaken, wherein only 2,750 posts were advertised. Now, and they were distributed subject-wise as per the requirement. Now, they say that they become eligible in this recruitment, which could not have been, because at the first instance when they participated, they were disqualified. That process having been concluded, they cannot now say that they would be eligible in the second process. Now, that is the contention of the main submission of the main plank of the submission of the state on behalf of the state government. So the reliance that they are placing on this judgment, your lordship, that dealt with the age relaxation, whether they would be eligible to participate in the selection examination 2023. It is not the identical matter. The matter relates to whether having once that process having been concluded, Whether after that retrospective benefit of reduction in the EWS qualifying marks can be given to the candidates who had already participated in that process and had been held ineligible.
Yes.
That is the issue involved.
Yes.
Lordship would see the memo of appeal for a moment and the grounds, my lord. What is being argued is totally contrary to not only your lordship's 15th October judgment. Lordship may kindly come to the grounds, my lord. I'll take your lordships one by one through each ground, my lord. Their singular ground is that the earlier selection process had ended and 2022 was a fresh selection, therefore no benefit arising out of 2018. Lordship would see the grounds, my lord. 3.1. Because the learned single judge failed to consider that the recruitment process in pursuance of the first advertisement of 29/12/19 issued by the School Education Department was concluded by the month of May-June 22 as per DOPT, and the EWS vacancies of the previous selection process could not be carried forward. Then they say it's a previous selection, which Lordship has said it's a continuation. Now 3.2, because the learned single judge failed to consider that admittedly the petitioner had not obtained qualifying percentage in EWS 60 at the time of first advertisement and therefore could not obtain benefit of the category in the earlier selection. They say it was earlier selection process. Lordship has said it is the same process. Second phase of appointment of the same process. Now 3.3, because the learned single judge failed to appreciate that though subsequently EWS category qualifying percentage was reduced to 50%, the benefit could not be given retrospectively to the petitioner in respect of already concluded selection process. Lordship has said no, it is not concluded. Then 4, because in pursuance of the vacancies notified in the second recruitment process, again the same thing. 5, because the subsequent amendment in the rules reducing the qualifying percentage will not be applicable retrospectively to the earlier advertisement which already stood concluded. Then 6, then my lord, vacancies cannot be carried forward in the next recruitment year. Hence, the vacancies were calculated afresh. Same ground, my lord. Then 7, because the learned single judge grossly erred in holding that once the vacancy position is notified, the same is to be filled by considering all persons who cleared the eligibility test by preparing the merit list. However, the learned single judge failed to consider that since vacancies under the EWS could not be carried forward as per DOPT memorandum. Now, carry forward is in the second fresh recruitment process, which your lordship has said it is not. Then 3.8, because the respondent tried to mislead the learned single judge by saying that EWS vacancies were reduced in the second counselling, whereas the first recruitment process stood concluded by the month. Not each and every ground, I am not troubling your lordship with all the 11 grounds. Common ground that the first recruitment process had concluded, and this was the second recruitment process. Therefore, we will neither give you age relaxation nor EWS benefit. I'm just taking a lordships to the few paragraphs where entire grounds have been answered in the negative in that judgment. Basic dispute that arises for determination is that which was the inverted comma first advertisement after 18/19/22 when the relaxation was granted by the state. The state has raised a very attractive argument that TET only relates to acquiring eligibility and that it has nothing to do with actual selection and qualifying TET. The actual selection process is concluded by issuing advertisements for selection. It was concurred by the petitioners raising argument that such repeated notices for appointment are not real advertisements, but it is actually a counseling process in the course of selection process that was kicked off by TET, conducted in 2018 for Uchchatar Madhyamik Shikshak and 2020 for primary teachers. Then in para 12, rule is quoted, my lord. 13. Therefore, now it is undisputed that a separate selection test is required to be conducted. And now in May 2023, indeed, a separate selection test has been advertised that has led to the entire dispute arising in the matter. The argument of the petitioner was that prior to 1/12/22, the TET was a composite test, that is eligibility test as well as the selection test. Now, para 13 is exactly the case before your lordships in this writ appeal also. They say that in 2022, it was a first advertisement, your lordship has said no. Under the rules, recruitment is by an examination which for the first time happened in 2023, my lord. Then, my lord, lordship would kindly come to para 17, my lord. I am taking a lordship to the last 4 lines of para 17. Thus, this public notice / advertisement for TET makes it clear as a noonday that no further selection was contemplated and appointments were to be made on the post on the fulfillment of other terms and conditions. During the course of hearing, para 18, learned counsel for the state was unable to dispute the position that no further selection test was conducted for the candidates who qualified TET in 2018 for Uchchatar Madhyamik Shikshar who was given appointment up to 1/2/12/22, on which date the rules were amended. Undisputedly, all appointments up to 1/12/22 were made without conducting any special recruitment test. 19. Therefore, this court finds substance in the contention of the learned counsel for the petitioners that the repeated rounds conducted for appointment pursuant to declaration of result of TET were nothing but mere counseling process for appointment because no further selection test was ever conducted. These notices for these rounds may be captioned as advertisements, but were never advertisements for any fresh vacancies, but were only repeated rounds for filling up approximately 17,000 vacancies that were announced at the time of notifying TET 2018. Then, my lord, Lordship may kindly come to my lord after the letters are quoted, my lord. Para 20, last 4 lines, my lord. Page 14 of the judgment. Para 20, last 4 lines. Nothing could be placed on record by the state to show whether any fresh vacancies apart from the vacancies forming part of TET notification of 18 were advertised by the state between 18/9/22 and May 23. Then, my lord, finally, Lordship would conclude, my lord, and para 25. Para 25, my lord, and 27, my lord.
Yes.
So far as the reliance placed by the state on the judgment of single bench in Seema Sharma is concerned, in the aforesaid case, the single bench rightly observed that after 1/12/22, the selection process is two-phased process and TET and selection process are now disjointed. However, the learned single judge did not have occasion to consider this fact that the selection test notified in May 23 is the first selection for new vacancies after COVID-19 pandemic, and that the repeated process that continued from 19 to 22 in pursuance of TET 18 for Uchchatar Madhyamik Shikshak were merely consequential counseling process pursuant to the result of TET 18 for the vacancies already notified at the time of TET 2018, because at that time TET was the qualifying examination as well as selection test. It appears that this argument was not so and so, so and so. So, my lord, my submission is, my lord, nothing remains to be decided. Each and every ground of this writ appeal is answered by this judgment. Only difference being that was age relaxation denied, saying that it's a new process of 2022. And here we are deprived the benefit of relaxation of EWS marks, my lord, on the same ground that it's a fresh selection process. We will not carry forward, we will not give you this benefit and carry forward these vacancies into 2023, which happened in, my lord, age relaxation matter. No difference, my lord.
May I submit, Your Lordship? Insofar as they even if for the sake of arguments, it is assumed that this was part of one selection process and they were only rounds of counseling in pursuance to the TET 2018. Then the petitioners herein, the respondents herein, the writ petitioners, original writ petitioners who are claiming benefit of EWS marks, they still stand ousted for the reason that the qualifying marks as per the then rules was 60% and none of them qualified. Since none of them qualified, if they say these are 2 rounds of the same selection process, then that same rule applies which was applicable to the first round of counseling, which was 60%, and they stand ousted. So none of them would get any benefit of this this argument that is raised by my learned senior. Secondly, I've prepared a short synopsis, Your Lordship, along with the list of cases. I'll just hand it over to you.
Related to the same person benchmark came to be appointed. But I'm just
yes, you want to intervene some argument later on. Firstly, my lord, I will submit, my lord, that intervener has got no locus in this case. They are the persons who participated in the process of selection, my lord, in 2020. And at their instance, my lord, the entry order was vacated and the permission was granted to the state to go ahead with the 23 recruitment. So as far as they are concerned, they are the persons who granted the, my lord, relief as far as their appointments are concerned. Now they have no, my lord, locus to meddle with the brilliant matter where they were not even appeared in the examination and they were not the parties.
now the Ayub by learned senior is saying that irrespective of the outcome will not be affected because we are of the subsequent selection process. There's no problem. And they're saying the post on which we came to be appointed should relate back to the earlier point of time.
We are not saying that. We are not saying that. I have not argued my case as yet.
I could read
Written submissions handed over also to the parties to be taken on record. list of such date for under the same caption.